There are many disadvantages of the jury system. These include: juries are not always representative of society. Individual jurors may be biased. Jurors may be easily swayed or lack skills. The secrecy of deliberations. High acquittal rates. The emotional impact on individual jurors and juries are expensive and time-consuming. Electoral lists are not representative as they do not include homeless or those in temporary accommodation. There is no right to a multiracial jury. This was established in R. v. Royston Ford, 1989, and confirmed in R. v. Smith, Lance Percival, 2003. The Runciman Commission on Criminal Justice 1993 recommended there should be a right to 3 jurors of the same ethnic group as the defendant or victim. Jurors are ordinary members of the public and may bring their prejudices to the courtroom. They could be biased for or against the police, class, age, gender, ethnicity, clothing, sexual orientation, or indeed anything. Baldwin and McConville, 1979, carried out research on 276 cases in Birmingham. The trial lawyers, police and judges completed questionnaires. It was found that there was a disproportionate number of black defendants in the questionable conviction category, suggesting racial prejudice was a feature in jury trials. In Sander v. UK, 2001, a juror complained to the judge of racial comments in the deliberation room. The judge allowed the trial to continue. The defendant was convicted and appealed. The Court of Appeal held that they were powerless to intervene since anything discussed in the deliberation room is protected by law. However, the European Court of Human Rights held that this was a breach of Article 6 of the European Convention of Human Rights, the right to a fair trial. Seeley and Cornish, in Jurors and Their Verdicts, 1973, conducted research using a mock rape trial and found that women were significantly more likely to convict on circumstantial evidence. Baldwin and McConville's 1979 research found a higher acquittal rate where juries consisted of more than 4 women. Jurors can be swayed by a number of factors. Other members of the jury may sway opinions. A strong minority can influence a silent majority. Media coverage can influence the jury. In R. v. Andrews, it was held that exposure to media coverage could not form part of jury vetting. In R. v. West, 1996, it was held that exposure to media coverage was not grounds for appeal. Juries look to the judge for guidance in reaching their verdict. Judges should be neutral in their summing up of a case to the jury. However, this is not always achieved. In the Birmingham 6 trial, during the judge's summing up, he gave numerous indications that the evidence of the police was to be favored over that of the defense. No qualifications are required to do jury service. Lord Denning, in What Next in Law, argued that jurors should be selected only from those who demonstrated the intellectual ability to serve. Section 20D of the Juries Act 1974 as amended by Section 74 of the Criminal Justice and Courts Act 2015 makes it an offence to disclose or solicit information obtained in the jury room. This makes appealing against a jury's verdict difficult as juries are not able to give reasons for their decision, as was seen in R. v. Sander in relation to the racist comments. In R. v. Young, the jury used a Ouija board to contact the dead victim to find out if the defendant was guilty. Such cases demonstrate the importance of questioning how the jury reached their verdict. Section 20F of the Juries Act now makes an exception for disclosure if it may provide grounds for appeal. Baldwin and McConville's 1979 research found judges had serious doubts over an acquittal in 32% of cases. Only a third of acquittals in Birmingham were seen as clearly justified by all respondents. Acquittal rates in the Crown Court are consistently higher than those in the Magistrates' Court, 57% as opposed to 30%. In summary, there are many disadvantages of the jury system. However, the jury is still widely regarded as a fundamental institution protecting the liberty of citizens and preventing an oppressive state. This video is part of a series of videos on law from www.e-lawresources.co.uk. Please subscribe to our YouTube channel www.youtube.com/e-lawresources. It's free to do so and will help us to keep providing these videos. Check out our website, which provides lecture outlines and case summaries. See also www.e-lawrevision.org.uk for revision games and quizzes. Thanks for watching.